Already, this hearing kicks off with a confession. Notice how the defendant blurts out drinking history before anything else is asked? In court, that's risky. Anything you say can be used against you, and oversharing like this sets the tone fast.
What is your name?
Seth Lewis, 25 Lincoln Street, Cadillac.
Do you have a telephone number?
375-4535.
Is that a 231 area code?
Yes, sir.
Do you have an email address?
No.
Did you have the opportunity to meet with somebody from the defender's office today?
I did.
In the first file, 3792, I have a complaint that alleges that on or about August 24th, 2025, in the city of Cadillac of Wexford County, it is alleged that you committed the offense of disorderly person under the city code. That is a fine of not more than $500 and/or a jail sentence of not more than 90 days. In case number 253793 SM.
Here's where it gets interesting. A disorderly person charge may sound mild, but in Michigan, it can carry jail time. Pair that with an assault charge, and suddenly this isn't just a slap on the wrist. It's a real fight for freedom.
I have a complaint that alleges that on or about August 24th, 2025, in the city of Cadillac of Wexford County, it is alleged that you committed an assault or an assault and battery. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500, and consecutive sentencing may apply if it happened in a place of confinement. Do you understand those charges and the potential penalties?
Yes, I'd like to know who the assault was supposedly on.
It was with a Christopher LaPrise.
Oh, that guy that's been doing down in the park. Okay.
All I know that those are the allegations. So do you understand that those are the allegations that you've been charged with and that these are the potential penalties?
Yes.
All right. Did you read and sign an advice of rights form at the jail, talked about your rights to an attorney and your rights to a trial?
Yes.
Did you understand those rights?
Yes.
You do have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointed.
And what is your source of income?
I was a cook at Ruby Tuesdays, but I just lost that job.
All right. Court will make a referral to the defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf, and will set these matters for preliminary examination. Pretrials. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I have received the praxis. His scores him at a risk level 3 or medium risk. He is currently on parole. Corrections, is there a parole hold on him?
I am not sure.
All right, thank you. Historically, counsel, I show an 02 possession of marijuana, 03 a joyride, 03 use of a controlled substance, 04 flee forth, 2 count.
Translation. If he's already on parole, this case could stack on top of an existing sentence. Think of it like being on probation at work. You mess up, you don't just lose your new job, you lose the old one too.
So that, in 04, a felonious assault, 08, operating while intoxicated, 09, assault and battery, 09, an attempted flee third and operating while intoxicated, 11, a resist and obstruct, and 14, a domestic violence and an attempted resist and obstruct, 15, a resist and obstruct and home invasion third, and 19, a resist and obstruct domestic violence, and 22, a domestic violence second and an attempted resist and obstruct, 22, a disorderly drunk, 23, resist and obstruct, assault and battery, malicious destruction of property less than $200, 23, a domestic violence third and disorderly drunk. In 1998, disorderly, 2000, assault and battery, 2000, trespass, 03, malicious destruction of personal property less than 200, 03, an attempted assault and battery. 03, malicious destruction of personal property less than 200. 08, disturbing the peace. 13, an attempted disorderly drunk. 21, illegal entry. 1997, an MIP. In 1997, an assault and battery. Any comment regarding bond from the defender's office?
Yes, Your Honor. The defendant stated he is homeless and is having trouble or had trouble in the past finding somewhere to stay and is now staying at the shelter or a shelter. I'm not exactly sure which one.
This moment humanizes him. The legal system doesn't exist in a vacuum. Homelessness, mental health, addiction, all collide here. The question is, do those factors justify leniency or highlight a risk to public safety? What do you think?
He did indicate that he needed reading glasses that he didn't have, so I don't know that he read his advice of rights form actually. Other than that, I understand the defendant's history. I would just ask for, or I'm still going to ask for a personal recognizance bond due to the particular charges being misdemeanors. And I do think that testing as the court determines might be a good idea in this case for public safety. Thank you.
Thank you. Mr. Lewis, were you able to read that advice of rights form?
My glasses are in my backpack. I don't know where that's at. So, but I know what it means. So I just signed it.
Well, I have to go through those with you. So while I realize you might understand them, I do have to go through them if you weren't able to read and sign them. So let's do that right now. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You have been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court, to have a trial by jury, and to the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you won't have a trial of any kind and you'll be giving up those rights. You have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted a court rule if the sentence includes incarceration. And if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights as I've read them to you?
Yes.
Do you have any questions for me about those rights?
No.
All right, thank you. Ms. Lawrence, comments regarding bond?
Thank you, Your Honor. While I know usually these charges are considered lower level misdemeanors, I do think there is an extreme concern for public safety in this case. The defendant had approached the victim near the railroad tracks and had made some statements accusing the victim of raping babies.
Notice how the prosecutor reframes things. Yes, the charges look minor on paper, but stacking intoxication, violence, and a stranger attack? That's how a misdemeanor gets treated with felony-level seriousness.
Pregnant women. He then attacked the victim, punching him repeatedly. There's no indication in the report that the defendant knew the victim at all. On top of that, shortly an hour later, officers received a dispatch to Harborview Apartments where the defendant was yelling and being verbally aggressive with some residents who were sitting outside, also accusing them of being rapists. He even rammed his bike into their picnic table. When officers found the defendant, he was clearly intoxicated. They found half-empty liquor bottles in his backpack, as well as multiple marijuana and THC vapes. Given this, on top of the defendant's multiple prior domestic violence and R&Os, I think there is a concern for public safety. I am going to ask for a no contact order with the victim, a no contact order with Harborview Apartments. The people would also ask for random drug and alcohol testing, including recreational marijuana, as well as a $10,000 bond. Thank you.
I'm sorry, but this guy lives behind the library, drinks vodka all day. He hollers at women and pisses in front of women and children. I'm sorry. I shouldn't laugh, but this is ridiculous. I'm sorry. I haven't drank in 2.5 years. I admit that I shouldn't have drank yesterday.
Sir,
I only 2.5 hours.
sir, I'm gonna advise you to be silent right now.
Right.
All right. The court does find the defendant as a threat to the community, given at least the allegations as presented to the court today in his numerous resistant obstructs and assault of past. I am going to order that the defendant appear as ordered, keep his contact information current, not leave the state without permission, and to commit no new crimes. In both files, he will be ordered not to consume any alcohol or illegal controlled substances, including recreational marijuana, and he will be subject to testing on both, random testing. I'm also going to order that in file number 3792, that he not have any contact with Harborview Apartments. That he not purchase or possess any firearms or weapons, and not act in any threatening, intimidating, or harassing behavior. In case number 3793, I'm also going to order that there be a no contact with Christopher LaPrise, that he not purchase or possess any firearms or weapons, that he not act in any threatening, intimidating, or harassing behavior. Mr. Lewis, if you are found to be in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Did you have a question, sir?
Yeah, just one question. So I'm not allowed to go to the library because that guy lives behind the library. The cops kick him out of the park all the time, so he goes and stays behind the library.
I'm ordering you that you not have any contact with him. If you have any questions regarding what that means, you can talk to your attorney.
This is almost darkly comedic. He's worried about the library rules while facing thousands in bond and multiple assault charges. But it also shows how vague, no contact orders can trip people up. One wrong move, even accidental, and he's back in jail.
But I will tell you that no contact means no contact of any kind, not by phone, text, email, social media, being in his presence, or anybody acting on your behalf. In case number 3792 OM, bond will be set at $1,000 cash surety. In case number 253793 SM, bond will be set at $5,000 cash surety. Thank you, jail.